Good afternoon. Let's get started. This is the House Judiciary Non Civil Committee. We are here to review several bills on the calendar today. House Bill 116 will not be considered today, so members take that off. On HB 9, you've got the, we're not going to take HB 9 now, we'll probably take it at the end. But we're reading on a substitute that's offered by the author, Mr. Blackman, at LC 297392S. So that's in your folder, I just want to make sure you have it. If anybody does not have 7392S, please let us know. Is Mr. Tanner here? I know that he had a conflict. Is there a member here who is working with Mr. Tanner on HB 30 to present on 30?
Bruce. Representative Broderick.
Well, I know that Mr. Broderick is on 231, but where's Mr. Broderick? Oh, I can't. Oh, Mr. Broderick, are you on HB 30 as well? Mr. Tanner's bill that adding synthetic opioid to Schedule 1? You are, let me put it this way. Since Mr. Tanner's not here, let me call Mr. Broderick for HB 231.
Chairman Cooper is also on that bill.
Okay. If during the course of consideration of House Bill 231, Mr. Broderick wants to present HB 30, he can. If not, I may just drag in Mr. Allen and we'll be fine. But it'll be Mr. Broderick's discretion.
Thank you, Mr. Chairman, members of the committee. I don't know how y'all were the luck of won the lottery and got me 2 years in a row on my drug update bill.
We historically have had the drug update bill
Yeah.
in this committee. We're happy to have it, and we're happy to have you here today.
Okay, thank you.
Yes, sir.
Thank you. I think in your folder, you've got a last-minute sub. The crime lab came up with a couple of new benzodiazepines that they wanted to add to the bill and were inserted last week.
Any, I mean, beyond the usual update, are there any unusual
No,
changes, differences from past year's practice?
No. If you look in Section 2, there are a large number of fentanyl-based entities that are there simply because with the heroin epidemic, fentanyl is being mixed with heroin, and the crime lab is seeing a large number of these compounds showing up in toxicology reports.
Thank you. I appreciate you bringing that up. Members, we're going to go ahead and take a look at that a little more closely in House Bill 213 on the calendar today. But any questions for Mr. Broderick on House Bill 231, the annual drug update? Mrs. Cooper.
Asked me to present a bill for him.
Yes, ma'am. We'll go ahead and was that House Bill 30 by any chance?
Yes, sir, but looks like to me that unless I'm mistaken, it's been added under Section 1 on line 11? No, they're different. Okay, thank you.
Yeah, just preliminarily, I think we have alignment and they're square between what Representative Tanner is doing, what Mr. Broderick is doing with the update, and what we're doing with the trafficking statute.
Sorry, Mr. Chairman.
No, not at all. I appreciate that. That's exactly the question that needs to be asked, for sure. Mr. Trammell? Mr. Setzler?
Hey, Mr. Chairman, I was just asking that, I guess, extend on Chairman Cooper's question. If both of these should pass, they're both labeled RR, same code section. Is there any conceptual reason that HB 30 couldn't be added as an amendment to 231 to make sure they're all in one place and they could move together as one bill?
I don't have any objection to that.
Mr. Allen, you got any, does that work logistically for y'all? Okay.
And Mr. Chairman, the nature of the question is, I think, to the substance of Chairman Cooper's question, paragraph or subparagraph RR would, if both would pass, I mean, that's something council could certainly blend together, but I don't want to miss the opportunity to put these together unless there's a policy reason to keep them as separate bills.
Council, can I get your thoughts on consolidation?
When they would, if they both passed as separate bills, when they were put into the code, they would be, given the lettering that went with the alphabetical order. Just quickly looking at it, I'm not sure which ones are and which one would be FF, but it would be blended together.
Mr.
Certainly the wisdom of the committee as to whether you wanted to join them.
But there'd be no issue with consolidation. Okay. Mr. Setzler?
And I just asked that, the appropriate time, Mr. Chairman, if it pleases the committee from a policy perspective, I might make the amendment to merge the two together and let council kind of clean up the numbering to make sure they're numbered appropriately so they could be one bill and travel together.
Okay. At the appropriate time after the motion by substitute would be to go ahead and to use the substance of LC 29-7196 as an amendment to House Bill 231, and then we'll just pass, and we'll take the motion by substitute. Are there any other additional questions? Ms. Ballinger? No? Okay. Ms. Ballinger?
Mr. Chairman, I'd like to make a motion to pass on LC 336878S.
Ms. Ballinger moves due pass of LC 336878S, which is House Bill 231 by substitute. There's a second by the Vice Chair. Are there any amendments, Mr. Setzler?
Mr. Chairman, I'd like to make a motion to amend HB 231 to include the addition of line 10 in LC 29-7196, which is the substance of HB 30. Now, Mr. Chairman, I will tell you, I did make the author of HB 30 pronounce that in subcommittee before I would entertain a due pass motion.
How did it go?
I would ask the chair not to require that of me in making the amendment.
That is a precondition for passage. That's been the policy of the committee for years, and we're not going to depart from that now. Yes, ma'am.
Mr. Chairman, I read 3,4-dichloro into dimethylamino cyclohexyl N-methobenzamide U47700.
Not bad. Good job.
That was so bad it was good. A second of Representative Setzler's amendment to add LC 29-7196 as an amendment to LC 336878S. Is there objection to the amendment? Is there objection to the amendment? Chair hearing none, the amendment is adopted. Any further amendments? Chair hearing none. On the underlying motion of due pass by substitute now of LC 336878S, which is now the substitute of HB 231. All in favor say aye.
Aye.
Opposed? The ayes have it. The motion is adopted. Thank you, Mr. Broderick.
Thank you, Mr. Chairman. Thank you, committee.
Let me, ask the folks from the insurance department to come forward to the table. We're going to go ahead and take up HB 213. While they're coming up to the table, this is a Department of Insurance bill, comes at their request. When it comes to the issue of, oh, I got the wrong bill. Here we go. Punishment for the manufacture, sale, or distribution of a proof of insurance document and the issuing of a fake or counterfeit insurance identification card. In Title 33, I understand that is considered a misdemeanor, a felony, and currently in Title 16, that's considered a misdemeanor. What House Bill 214 does, and there is I believe there's a substitute. Was there a substitute?
I have a substitute. It should be in your folder. What is the LC number of the substitute we should be referring to, Mr. Chair?
Hold on one second. Okay, we're going to suspend consideration on 214 while the substitute's being copied, and then we'll come back to it.
Okay.
Okay?
So okay.
In the meantime, let's redirect our attention to House Bill 213. House Bill 213 is a very straightforward bill, and actually, coming off the conversation we just had with Representative Broderick, it seeks to add fentanyl to the existing drug trafficking statute in 1613-31. I brought this bill, two reasons. First was some local feedback from our district attorney's office in Cobb County, specifically from the chief narcotics prosecutor there, Jason Saliba, who unfortunately could not be with us today. What they're seeing more and more is fentanyl being added as a product that I guess is cutting. They're using they're cutting heroin with it, and as a result, the product that's coming out is a much more powerful, much more deadly product than they've seen on the street in a long time. I can tell you from personal experience, the child of a friend of ours, a very close friend of ours, had been a heroin addict and was clean for about 4 or 5 years, several years, and went to college, was about to graduate, and got anxious, for lack of a better term, and used, and it killed him. Now, as you might expect, when you've been clean for 4 or 5 years and you use something like that, it's going to have a large effect on your body, a shocking effect on your body. This would take that and just times that by 1,000 by virtue of the fact that there was fentanyl used in that product. He wasn't trying to kill himself. He was trying to get high, use, whatever you want to call it. There's no indication that suicide was intended at all, just the opposite. And but he did get nervous. He used the product, the heroin product had been cut with fentanyl, and he died. That's what we're seeing right now. More importantly, that's what law enforcement is seeing, I understand, right now. I know the GBI and the Narcotics Agency is here. If any law enforcement want to come up and just speak to that in terms of what's actually being seen on the street, that would be helpful, I think. It's one thing if I say it. It's one thing if law enforcement themselves can go ahead and give us their fresher perspective.
Good afternoon. My name is Danny Porter. I'm the district attorney in Gwinnett County. I'm also the legislative liaison for the District Attorneys Association of Georgia. I'm also in the district attorney of what has been labeled in the press as the drug hub of the East Coast, or at least of Georgia. And I can tell you that over the last 4 years, we have literally seen something I would have never believed, which is that fentanyl is being used as a cut agent in heroin. And what the net effect of this is just as the chairman described, is heroin has a certain potency, and when you mix it with fentanyl, you boosted the potency approximately 1,000 times. So someone who thought they were taking street-level heroin in a needle or snorting or smoking is actually ingesting something that's about 1,000 times stronger. Fentanyl has a legitimate purpose. It's medically used for end terminal patients to relieve intractable pain, and it works. But, and to be honest with you, I don't know. The only thing I can figure is that it's harder to get morphine out of the Middle East now, and it's easier to get shiploads of fentanyl to Mexico from China, and therefore they're mixing it that way. But it is, in 2016, we had 17 deaths that we can directly connect to injection of what was represented as heroin, but was heroin cut with fentanyl, and it's cut of varying degrees. And if that doesn't concern you, there's also what's called carfentanil, which was developed as a tranquilizer for large animals, and a surgical, which is it's some magnitude higher than fentanyl. And now there's a drug called W18, which is a synthetic opiate developed, and it's thousands of times more powerful than morphine, and it's being sold as China White. And the bill you just passed will allow us to enforce all of these under this current bill because it creates what's called a backbone of fentanyl products that allow us to catch all of the synthetics.
Questions for Mr. Porter? Ms. Quick? Oh, I'm sorry. Ms. Price?
Thank you. What do I have to do?
Is it 18?
18, thank you.
Mhm.
Thank you, Mr. Chairman. Having used fentanyl a lot in my professional career, as well as its derivatives, sufentanil, alfentanil, I'm not sure the bill with its wording covers all those derivatives.
It does if you take it in conjunction with the bill that you just passed, which, and the crime lab can explain, the chemist can explain it better, but under the definition of fentanyl, we have included all the derivatives and precursors.
Because it seems like everywhere there's the word salt isomer or salt of an isomer, is there any reason not to put derivative there, or is that too imprecise?
You'll have to get the answer from the scientists who help us define these, but that, there is a reason, I just can't give it to you.
Mr. Allen, do you mind? Okay.
Good afternoon, everyone. Mr. Chairman and committee, thank you. Let's see if I can explain this.
Can we
just-
ask who, if you could just let us know who you are and who you're with?
Absolutely.
Thank you.
My name is Deneen Kilcrease. I'm with the GBI Crime Lab, and with the drug chemistry section. So ultimately, I'm responsible for all chemistry that leaves the GBI Crime Lab. Okay, so these bills are really doing two different things, and they're talking about two different compounds. House Bill 213 is specifically related to the trafficking of fentanyl, just fentanyl, and its salts and isomers. House Bill 231 actually talks about the fentanyl analogs that are going to be placed into Schedule 1. So they are actually two different things that we're discussing here. So 213 is just going to cover fentanyl the same way that heroin is covered. So 4 grams, 14 grams, and 28 grams. It's going to be controlled the same way regarding trafficking. 231 is going to take all of these analogs that are so dangerous and so potent, and it's going to make them Schedule 1. I don't know if that helps clear up your
Well,
question.
I guess what I'm trying to ascertain is, can somebody still traffic alfentanil?
Yes.
So then why aren't we taking care of that?
This was the way it was written, just to include fentanyl and the salts and the isomers and the salts of isomers. It was not written to include the analogs of fentanyl.
Do we do better to make that change?
From what we're seeing in the crime lab, there are not that many trafficking cases. To actually give you some hardcore numbers, we had in fiscal year 2015, we had 47 fentanyl cases. In fiscal year 2016, we had 71, and so far, we're halfway through fiscal year 2017, we're at 37. So we're on track for about 80. One of these cases, one was a very large case that made the news. It was 40 kilograms of pure fentanyl. There was another case that was 500 grams. Short of those two cases, there haven't been that many with this kind of weight associated with them. Typically, we see much lower weights. So the way this was written up, it is just going to include fentanyl and isomers and salts of isomers for trafficking.
Or any mixture thereof. So it would be, you could have a heroin fentanyl mixture, you could have a.
Right. I guess what and to Ms. Price's question, which I think I share the concern, is that if we simply just add it under the trafficking statute, is there and I know this is the wrong word, but is there a hybrid that if it's used and it's trafficked, that we would not scoop up with making the change that we've made over proposing to make on 213?
Okay, so I'm hoping I'm understanding your question correctly. I'm sorry, I'm trying to make sure I'm understanding what you're asking me. Right now, the analogs of fentanyl are not controlled unless they're specifically listed. Section 1 of the annual drug update, Section 2, and 3 removed all of those specifically listed fentanyls and created a backbone for them. Okay, so they're all going to be controlled under Schedule 1 with the analog with the backbone statute. Now, the Schedule 2 fentanyls, such as carfentanil that was mentioned, those are left alone. Those are specifically named, specifically listed because they do have medicinal or veterinary purposes. So those were left specifically listed. The trafficking statute is only going to apply to fentanyl. It's not going to apply to the Schedule 1 analogs.
Okay, so then, would it then make sense then, again, to Ms. Price's point, to expand our definition of fentanyl for purposes of the trafficking statute in order to not miss a potential group of substances to be prosecuted?
It's my understanding that the
Or does the backbone cover it?
untimely deaths are more, it's hard to kill somebody with just fentanyl, but it's really easy to kill them with some of the others. I mean, kill yourself or pass it on to somebody who doesn't understand the potency.
Ms. Cooper?
Thank you, Mr. Chairman. And often when we tighten up something, like the fentanyl under Schedule 1, then the bad guys go and find another way to work. So it seems like to me, unless there's a specific reason that the analog shouldn't be in there, I think that Representative Price has a good point. Because if we get tight on one, even though there are not that many deaths from fentanyl, it's a growing, and we're going to cut off one avenue, I think we need to cut off the other avenue.
But the deaths are probably occurring from the other drugs.
I do
I mean,
have.
I don't have any facts on that, but it's my understanding that these highly, highly potent drugs are the problem.
So then I guess what I'm hearing is it leads us to the question of what is the way to draft it such that it will gather up this broader universe for purposes of the trafficking statute? Is that necessary?
The one issue that you have to think about, and Representative Price, to go to your question, I can only go to the autopsy results, and the autopsy results show in the deaths in Gwinnett County, we know from other investigative means that the drugs were sold as heroin. We know that there is some heroin in the autopsy results, but there's a vast majority of fentanyl. So I don't know what, you're the doctor and I would not, I'd defer to you, but there's the drug we are seeing that's being trafficked and used by the cartels is fentanyl. We don't see the derivatives, or very rarely do we see any of the other derivatives of it. So it would be a matter of, do you want to decide now to combat an existing problem where you're charging trafficking with what is a legal Schedule 2 drug, whereas you take all the salts and isomers and make them a Schedule 1, which has no medical purpose and carries the maximum penalties under our drug code. But everything we're actually seeing, we see almost no derivative cases. They've got a supply of fentanyl somewhere that they're mixing with the heroin they're getting. That's what we're actually seeing.
And I do have some statistics too about the derivatives and the fentanyl analogs. We have only seen 3 carfentanil cases at the crime lab, 3. And actually there are 141 overdose deaths for 2016 as a direct result of fentanyl. We have a few more cases pending, so that number may go up just a little bit, but there were 141 deaths and only 3 cases of actual carfentanil and no overdoses as a result of carfentanil. Now we've already talked about U-47-700. We have 7 overdoses contributed to that, and typically what we see at the crime lab is a very deadly mixture of heroin, fentanyl, and U-47-700.
So, Mr. Porter, and I just want to make sure that I've got my head around it, to make sure we're as broad as we can be within the realm of realism. From a pure trafficking statute, you're not seeing the derivatives that
We're not seeing the derivatives, so that the language that exists in the bill will move fentanyl, the actual substance fentanyl, into the trafficking statute, just like heroin or the other drugs in that section. If you wanted to include some of the other derivatives, then, or salts, isomers, or a mixture thereof, then you would have to specify those in the actual code section.
And you're not seeing those as a practical matter right now?
No, sir.
Right now?
No, sir.
Okay.
And I think that has to do with they're harder to get, they're harder to make. I never thought in 30 years I would see fentanyl as a cut, but it is. So.
Ms. Ballinger?
District Attorney Porter, would you be concerned that the drug dealers, if we do add fentanyl, would just go to one of the derivatives that, you know, I mean, they're pretty smart, they're pretty savvy. If they figure that out, wouldn't they move to something and kind of utilize that loophole?
Again, I'm going to defer to the crime lab, but my experience is we're seeing fentanyl in methamphetamine. I think they have an oversupply of fentanyl. I think there's a ship somewhere with 55-gallon oil drums of fentanyl, and they're just mixing it with everything. And so I don't know that they have access to some of these others that would allow them to very quickly switch.
Exactly.
Mr. Setzler?
Thank you, Mr. Chairman. And I would open this up to either District Attorney Porter or the GBI. If this bill had the other derivatives in it, what would the argument be from you to take those out and only have fentanyl? If you flip this and fentanyl's going to happen, it's going to make it across the goal line this session, what would your argument be to this committee? Please take carfentanil, these other derivatives out of this bill. It's problematic. What would that argument be?
I don't think there is any argument.
No. No argument whatsoever. In fact, if you wanted to merge the two, like you guys are talking about, you could simply reference the code section from the fentanyl analog code section. You could include heroin, morphine, opium, and then substances included in, and then reference the other code section if you wanted to blend them.
That's helpful, Mr. Chairman.
Instead of the word fentanyl, you would say substances as described in section 413. It's at line 36 in 231. Begins at line 36 or 37 and goes on to about 125.
Okay. So, Mr. Bodie?
I think this is a question more for the chemists. Have you all seen any cases where a derivative of fentanyl has been more than 14 grams?
Not that I'm aware of, no.
Okay.
Any further questions for Mr. Porter?
Okay, where's that?
Seeing none, let's do this. Let's suspend consideration of House Bill 213 for now. We'll carry it over to the next meeting, and we'll think about gathering up. We'll think about really starting with the point that was brought by Representative Price, and then see how we can just cleanly, bring all that in. It probably makes sense to do so, and there's no reason to not bring it in if we can. Did you have any further thoughts on that?
Well, I do, as to what we just immediately prior to that passed. Did we not pass 231 sub?
We did.
Okay, I just want to make sure that there is an exclusion for all these fentanyl analogs since they are used in bona fide settings.
Yeah, that's why I want to take
But we just passed that.
we did, but I want to go, we did, but I want to go ahead for the purposes of 213, make sure that, take a little extra time and make sure that anything we do in that particular bill will make sense and be in alignment with what we've done on 231.
Again, I may ask that we revisit 231 unless there is an exception for the legitimate uses of the fentanyl analogs.
I think that exists
There is.
now.
Yes, sir.
So I think
Okay.
the confusion maybe is the Schedule 2 fentanyls were left completely alone. So everything that there's a veterinary use for or a medicinal use for, we completely left that alone. We only added the analog part to the Schedule 1.
Well, but that's what I'm saying. There are some analogs that are legitimately used as well.
And those would be listed in Schedule 2, which we left those alone.
Okay, I'll look at that later. Thank you.
You're welcome.
Yeah, let's take, we'll take our time on that just to make sure that's clear. I want to make sure Representative Price's concerns are addressed. But yeah, we certainly don't want to have the law of unintended consequences kicking
Mhm.
in with regard to legitimate use of fentanyl, but also making sure that we're doing everything we can on the trafficking side to combat an ever-increasing problem, as per the comments of District Attorney Porter from Gwinnett County. So let's redirect our attention to House Bill 214, and I'll ask the Insurance Department people to come back if they would. Appreciate their patience. Right now on the issue, and this is again is a bill brought to us at the request of the Insurance Department, right now as it relates to conduct of the unlawful manufacture, sale, distribution of a counterfeit or false proof of insurance document. In Title 33, that conduct is criminal and it is punishable as a felony, whereas in Title 16, it is currently punishable as a misdemeanor. So that's obviously in conflict. What the department is asking us to do is to align those so that the provision, the applicable provision in Title 16, which you have in your substitute for House Bill 214, which is LC 297405S, also reflects the fact that it is a felony just as is treated in Title 33. Felony 2 to 10, not more than $10,000 fine. I'll ask our friends in the Insurance Department if I described that accurately.
Yes, Chairman, thank you. Lindsay Scott with the Insurance Commissioner's Office. Sherry, I'll let you introduce yourself.
Sherry Mowell, Director of Fraud Investigations.
Thank you for carrying this bill for the department. We certainly appreciate it. This issue came to our attention, was it over the summer, Sherry?
Yes.
Just recently when a district attorney referenced the 1695 when they were defending a client, as I understand it. And the judge then handed down a judgment using that lesser charge. And it was a serious case involving workers' compensation insurance. And we had some concerns about that. At that time, it was Sherry that said we need to correct this conflict that exists, and that's where we are with the legislation today. I did have some questions when I was talking to some committee members on Friday. One of those questions was with regards to possession of a false proof of insurance. That we are not changing. That will still be a misdemeanor. So just wanted to address that too.
Any questions for the department? Any questions for the Insurance Department on House Bill 214 and their substitute LC 297405S? If not, what's the pleasure of the committee?
Move to pass.
Vice Chair moves do pass of House Bill 214 by substitute LC 297405S. There's a second by Ms. Ballinger. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye.
Aye.
Opposed? The ayes have it. The motion's adopted. Thank you.
Thank you very much.
Let's move to House Bill 9, Representative Blackman. And members, again, we're working off the substitute LC 297392S. This is a substitute, if I recall correctly. This was not the substitute that passed out of subcommittee. This is a substitute that the author has had counsel draw up, which is, I think, very near the subcommittee substitute, but not quite. So the author will be speaking from that. What I'll do, Mr. Blackman, is recognize you to speak to the substitute. Then I'm going to get a report from the subcommittee chair, and then we'll go from there. Sound right?
Yes, sir, Mr. Chairman. Thank you.
Okay.
May I invite the
Oh, sure.
young lady,
Absolutely.
the victim in this particular case,
Absolutely.
to join me up here?
Sure.
And I may request later, Mr. Spahas with PAC, but I want to thank you for the consideration, Mr. Chairman, members of the committee, on House Bill 9. Just to go into a little bit of background, back this summer, the Georgia Court of Appeals in a 6-3 decision overturned a conviction from my home county of Houston County. And I just wanted to recognize this young lady to my left, to my right, who is the victim in this case, very courageous young lady who has, her and her family have seen to it that this has been addressed in a proper fashion. And this young man now that committed this crime, that we all believe to be inappropriate behavior is now free. The majority opinion in that particular case basically directed us as legislators to address the gap in existing law. And if I may, based on a number of fellow House members and the PAC and others, we came up with House Bill 9. We dropped it pre-filed early back in November and hope to vet it properly and get it through this session. I'd just like to read real quick a little bit of this bill. Obviously, what it's designed to do is prohibit the use of a device to film underneath a person's clothing under certain circumstances. Down on line 19, if I may, it shall be unlawful for any individual to knowingly and without the consent of the person observed, use, or install a device for the purpose of surreptitiously observing, photographing, videotaping, filming, or video recording such person underneath such person's clothing for the purpose of viewing intimate parts of the body or of the undergarments worn by such person, under which circumstances such person has a reasonable expectation of privacy. Now, we have a couple of exceptions there, Mr. Chairman, members of the committee. With respect to law enforcement and prosecution agencies, and then we also have any devices that are installed of a business or entity in which signage is conspicuously warning of such surveillance. That is the bill in short. I'd be happy to answer any questions.
We'll get the report from the subcommittee chair on this particular bill was Chairman Setzler, and then we'll go to questions. Mr. Setzler.
Thank you, Mr. Chairman. Representative brought a bill that's quite a bit of work had gone into. There were some concerns in subcommittee that came up policy-wise and technically. The issue came up regarding what technologies could potentially be used and whether this was just an upskirting bill or the ability to look beneath someone's clothes from the top or even through with certain thermal devices and so forth. So I think the language that is in the substitute addresses that underneath such person's clothing. Also, Mr. Chairman, I think that there was an issue raised about, was it just photographing, videotaping, or did it need to include observing? Even if it were for a temporary period of time, not capturing it, but observing it. That was picked up in the substitute as well. The term observing on line 21 addresses that. And then also Representative Trammell raised, I think very importantly, towards the end of the bill, lines 31 and 32, really buttoning down the language around a business's surveillance device, that couldn't be used in an inappropriate way, but that it in fact was intended to include the kinds of cameras you see in changing rooms and those kinds of things, and security cameras, not something that could kind of use this code section inadvertently and twist it for bad purposes. I thank the author of the bill for making those changes, and we moved it forward with a DuPass recommendation on the commitment that those changes would be made before full committee, and that's the substitute you see before us now, Mr. Chairman.
Thank you, Mr. Setzler. I just had a quick question on, and I don't have strong feelings about it, but I just wonder from a drafting standpoint if we even need the second sentence in A1, beginning on line 14, without limiting the generality of the foregoing, et cetera. I'm not sure if we actually even need that sentence. I think it's more illustrative, certainly, but when you have a device, means, an instrument or apparatus, there's no limitation on that. But then we're getting into specifics. Again, I realize it's not limiting it, but I just wonder from a drafting standpoint if we even need it at all. Was there any conversation about that in the subcommittee, or?
We did not address that in subcommittee.
Okay.
Committee,
Again,
Mr.
I'm
Chairman.
not,
Perhaps council's got thoughts on that. But
I don't have any strong feelings about it. I just wonder, it doesn't seem as if it's completely necessary, but certainly the second sentence is not doing any harm or confusing the first sentence. Is that council's? Wow, that's fantastic. Yeah.
Mr. Chairman.
We get a recording of that.
Ms. Travis, was it at one time that we sought to include mobile phones specifically and that such that, technology has changed over time. Gotcha.
Okay, questions, members of the committee? Ms. Kendrick?
One of the things that came up in the subcommittee was about the wording such that it was underneath. I think that the original wording was underneath and through, and I was asking about if somebody could do what's the term for it, when somebody looks down
D-
your blouse?
You gonna make me say it?
I don't remember the name
I'm
of
just
it.
kidding. Down blousing, I
Yeah,
believe.
down
Yes,
blousing.
ma'am.
And you said it seems like you just took care of it with line 22, underneath such person's clothing, so that it's just underneath. Is that?
That was
what it
our attempt, yes, ma'am.
And then my second question is on line 31. I actually brought this up, dealing with the surveillance device. I see you added, and the use of such device is primarily designed to detect unlawful activity. Is there a reason why the word primarily was used as opposed to the device is just designed to detect unlawful activity?
Well, there may be other instances where somebody might use surveillance. I cannot think of one right off the top of my head, but we thought that there could potentially be some other reason. Mr. Spejas, would you like to address that one?
We were definitely trying to establish some sort of weighing test about the proper use of those cameras, so that's where the language came from.
I think as an employer, you could always use the cameras to, maybe you're not trying to get unlawful behavior, but maybe just, employees goofing off.
Yeah, seeing who's hiding,
kind of,
working.
Clocked out early, left.
having a cup of coffee and then, taking a nap in the dressing room or something like that. Not that I've ever done anything before.
Thank you for your question. Yes, ma'am.
Mr. Bodie?
Well,
Did you have a question?
Well, I didn't have a question, but I did have a thought, Chairman. And I can't quite remember if we said in subcommittee that the signage, and I don't know if this is even appropriate to say, dressing rooms or any other places that maybe somewhere they need to have signs. Kind of like when you go into a store, when you first walk in, it says, "Don't shop there." You shop there, you can see, it'll be a big sign with a camera. I don't know if we need to kind of maybe map out a couple of examples where the signage needs to be other than the dressing room. It was just a thought.
Mr. Chair.
Let me get to Ms. Dickerson. We'll come around. Ms. Dickerson?
Yeah, my question was, why the age of 16? Could that be reduced?
Well, if you're under the age of 16, there's another section of the code that can address that. It's
Okay.
sexual exploitation of children.
Okay,
And so that was the reason for that cutoff.
Okay. Thank
Yes.
you.
Yes, ma'am. Thank you.
Who was 17? Ms. Quick?
Thank you, Mr. Chairman. I sort of find myself in the unfamiliar place of asking a question about whether or not the government is adequately protected. In the term law enforcement and prosecution agencies, does that protect Athens, Clarke County, for example, in the jail or holding cell situation where somebody may be incarcerated or there's somebody there, some lawyers got locked up on a civil contempt or something like that, and there may be some surveillance equipment that's capturing here that might subject the government to a suit? Anybody have any thoughts on that?
Well, as a non-attorney, I probably wouldn't be best served to answer that very insightful and probing question, Representative Quick. But I do know that we did adjust the language in that line to include lawful activities. Now, I don't know if that would necessarily address anything that you're referring to.
Okay, thank you.
Yes, ma'am.
Just to be clear, we're talking,
Would that be captured by the lawful activities of law enforcement and prosecution agencies? Would that be captured?
Mr. Spayhouse, you want to, can you address your comments forward just to, so we can have the benefit of them?
So if you want, I've got a little, now that Representative Quick brought it up, I am concerned about the qualifying language if it has to be an investigation or prosecution of criminal offense. She makes a valid point. The jail is in the business of detaining the individual, not, and they're supervising the individual and not investigating or prosecuting. You could have a broader, safer language if you just stopped at the end of agency and not use an investigating and prosecuting criminal offenses, just the lawful activity of law enforcement and prosecutors. That's what you're after, I think.
Be a clean strike after the word agencies, semicolon after agencies. Ms. Quick, you want to consider offering that at the appropriate time?
Sure, Mr. Chairman, I don't know that I'm.
You've got time. I think what he was saying was the possibility of on line 28, simply putting a semicolon after the word agencies and then striking the rest of line 28 and 29.
Leaving or.
Leaving or, yeah.
Yeah.
Just think about that. Ms. Price.
Thank you, Mr. Chairman. Representative Blackman, in our effort to conserve ink, I want to offer another suggestion.
Of course.
And that is the end of line 24 and all of line, I'm sorry, the end of line 23 and all of line 24, unless there's a compelling reason to include under circumstances in which the person has a reasonable expectation of privacy. I'm racking my brain trying to think, when would you not have an expectation of privacy?
It is very material, Madam Representative, and in so much as I understand your question, but if I think we use a example of somebody who is probably revealing a little bit too much, and somebody takes a photograph there, then that person really doesn't have a reasonable expectation of privacy if they are in fact showing their intimate parts or their body or undergarments. Does that make sense?
Yes, but I'm trying to think of situations such as, communal showers, what have you, where you don't really have an expectation of privacy, but you would have an expectation that no one's filming you.
Well, that would be, more so of the place where you might have a surveillance issue, and that's covered with respect to that line. I'm not sure exactly what you're referring to. I think perhaps maybe it's.
Well, I'm trying to anticipate that somebody would say, I'm excluded because this person didn't have an expectation of privacy.
Well, that would be an argument. Yes, ma'am. That's I think that's
So-
material to the language in this bill.
It seems like we hurt the bill more than help it with that line.
I'm not sure I understand why you believe that to be the case, but I understand what you're saying, Madam Representative. And Mr. Spayhouse may want to address that himself as a prosecutor.
If someone could elucidate that, that'd be great.
The best description I could come up with would be a wet t-shirt contest or some other time an individual exposes their undergarments to the public. At that point, they don't have a reasonable expectation of privacy to be protected from being photographed. That's the balance, I believe, that the subcommittee was looking for when that language came in there. So it's, as long as you're trying to cover up your clothes, then you've got a reasonable expectation of privacy. If you have exposed your underclothes to the world and photographing has taken place, then it shouldn't be a felony.
I mean, do you have expectation of privacy in your own bathroom when you're changing from the shower and your window?
Sure you do. We've got other
That's a
protections that cover
Okay,
that.
so that's,
This is about
different
the,
part of the code. Yes,
yeah,
sir.
so that you've got keeping calm and you've got invasion of privacy and all of that that's in this same article. So this is a much more narrow concept.
okay, thank you.
Vice Chair.
And to that, just be reminded that one of the other earlier elements is consent. So for example, a communal shower, someone were to take a photograph or in some way commit one of these actions, consent is also one of the keys. And so whether, most likely in that scenario, nobody would give consent to that type of thing. It's just an additional element that the state would have to prove.
Knowingly and without consent, yes. Yes, sir.
Mr. Strickland.
Thank you, Mr. Chairman. My question deals with the second exception to violate this code section, you have to have the purpose of viewing the intimate parts of the body or the undergarments worn by such person. When does an entity or a business ever have a legitimate purpose for doing that?
Well, this came up in sub, and I think one of the examples that was listed is, you know, a lot of times if people go into a dressing room, there are some that potentially, unfortunately, will participate in criminal behavior, theft, and whatever. So sometimes you might have those kind of surveillance cameras in there to prevent something like that from happening. I'm sure if I sat here long enough, I could think of other instances.
Mr. Chair.
Representative Strickland.
I'll let him.
Can I answer his question, Mr. Chairman? The issue came up in subcommittee around if there was a dressing room where you would normally have an expectation of privacy, but let's say the video camera were being used by creeps. I mean, literally, they're using the changing room to attract people in to take their clothes off, and then you're exposing this to anybody you want to. Heck, you're charging admission to watch, you know, women in a changing room or something like that. That it's the element of requiring it being used primarily for security purposes and not giving businesses this carve out to be able to film people in places was sort of a catch the subcommittee had. Does that answer your question, Representative Strickland?
Yeah, my fear is.
I'm sorry, I didn't understand the question.
No, I think you answered the question too. My fear just says with that broad exception at trial, that's the defense you're going to see someone use in a dressing room. I just didn't know if, and maybe I'm wrong, maybe there is a time where, I mean, there's still an underwear. I'm trying to think of an example why you need to view the undergarments in a dressing room. And maybe there are examples where you need that exception in there, but I was worried about someone using that at a trial as their defense in this.
Well, but the whole obviously the shoplifting scenario, you'd be surprised what people will do just to steal a minor trinket, and
garment.
They'll store them nearly anywhere.
Right.
So, I mean, that's obviously a legitimate purpose. It's been around forever, but it's to go to Mr. Setzler's example of, you know, someone then bringing in non-employees, unauthorized individuals into that room, you know, for another purpose other than the lawful activity of the normal course of that business and the security aspect of that particular role, and observing, you know, through the mirror, you know, what's going on in there. That's when you cross that line, if I'm understanding it correctly.
So we go down to the primarily designed to detect unlawful activity would be how you come back on that.
It's a strong attempt for us to kind of narrow this as best as we possibly could, because obviously, you know, if somebody goes in and they try some jeans on and they don't want to pay for them and they want to take them off and slide them in their purse, you want a business to be able to catch that type of behavior.
Right.
But at the same time, if somebody were to slide their cell phone in there and there's surveillance already taking place, we don't want them to have clearance, so to speak, from this code section. So it's our best attempt to narrow that as best we can to try to catch folks that are participating in bad behavior, and at the same time protect those that are doing things lawfully to protect their business.
So do we need the word primarily? I know that was discussed a minute ago. Does that word need to be there?
It was discussed, Mr. Chairman. I don't know that I have a strong opinion about that personally.
We're comfortable that that's a good balance.
Okay. Okay, thank you.
Thank you.
Mr. Tremmel.
Thank you, Mr. Chairman. On the same point, for the author and for the committee is more of a suggestion with regard to language at line 30. I think the chair just hit on it, is a business's or entity's use of a surveillance device in the ordinary course of its business. I think the ordinary course of business is a term that you find in 161160 for some of the exceptions for electronic provider, and is an important limitation on that it be consistent with their ordinary course of business. I would just ask the author of the bill if that's consistent with your intent.
You know, it seems to be, Representative Trammell, and you and I have discussed this. I would probably defer to Ms. Travis a little bit, since we did just go over this several times to try to find an appropriate wording that would cover this very instance that you brought up in sub. So we can take that into consideration.
Mr. Spaos, did you want to?
I would caution us to be careful about getting away from the surveillance device itself belonging to the business or entity. So let's not authorize anybody that works there to use a device for this purpose. So if we're going to qualify, if we're going to use a different language other than primary, let's stick with the concept of the surveillance device belonging to the business or the entity, because that's what we all understand to be that legitimate camera that you're put on notice is there, as opposed to an employee that would, in this same environment, then use their phone. As far as the test that you used, I mean, that's probably another way of saying almost the same thing. I just make that one caution.
Mr. Bodie? Mr. Bodie, do you have a question?
Yes, I just had one question that came up with Representative Silcox in subcommittee dealing with a private investigator. I think you had brought that up. I don't see that language there. I don't know if it's necessarily a big issue or not, but I didn't see any modifications or any amendments, so it may be a reason why it's not put in there.
No, I think we addressed that question in subcommittee. I think Mr. Spaos had some comments along those lines.
Because it's addressed in the other parts of this article.
Okay.
Surveillance and what have you, and the exceptions for legitimate surveillance are all addressed in other parts of this article.
Okay. Thank you.
We were talking about someone's home and such.
I see no further questions. Thank you, Mr. Blackman.
Thank you, Mr. Chairman. I appreciate your consideration.
We've got one person signed up to speak to House Bill 9, Chief Billy Grogan, on the behalf of the Georgia Association of Chiefs of Police. Chief, welcome back. Always good to see you.
Good to see you. Mr. Chairman, thank you for the opportunity to speak on HB 9. In Dunwoody, I'm the current police chief. I'm also the president of the Georgia Association of Chiefs of Police. And this is certainly an issue in my community and many communities across the state. We've had already in 2017 2 incidents in which we couldn't arrest the subject. As you know or may not know, in Dunwoody we have Perimeter Mall, a big retail area, so certainly this is a big issue. We had a number of incidents last year and really over the last 4 or 5 years. And we've even had a serial, what I would call a serial upskirter that was arrested before the court ruling came out. And he had previously been arrested in Alpharetta a number of times, in Roswell, and I think on his phone had hundreds of photos that he had taken up a women's skirt. So it's an important issue. We certainly appreciate your consideration of the bill. I may can add some clarity to the dressing room issue. I'm not aware of any of the retail establishments in Dunwoody or really anywhere else that actually has cameras inside the dressing room where you're going to see somebody taking their clothes off. They have those in the common areas where they enter so they can see how many items of clothing they're taking in, how many items they bring out. If it's a large dressing room and there's hallways to individual stalls, they have cameras there, but not inside the actual dressing stall where they can see someone take their clothes off and, you know, get naked while they're trying on other clothes.
Don't you think, I mean, as a practical matter, and I don't know to what extent that's practiced in retail right now, but obviously you've had individuals on the opposite side of that mirror to prevent shoplifting, given the fact that that was and perhaps still is, I assume it is, ordinary custom and practice, isn't it just a matter of time before they use a camera as opposed to a person to do that?
Well, I'm not aware of any that's actually inside the dressing stall.
Not inside, but I mean,
yes.
perhaps on the other side of the mirror where they have some ability to film through the material. I don't know. Just in some way, shape, or form, at some point, business, if they can go ahead and not have that employee, but rather do it electronically,
Sure.
they will.
Sure, if they can detect it.
Sure.
Yes, absolutely.
Don't ask me how it physically gets done, but it'll happen. I mean, it's just a matter of time, technology. Questions for Chief Grogan? Seeing none, thank you, Chief. Thank you for what you do. I want to thank the subcommittee I want to thank the author for bringing the bill and being on-the-spot responsive when the Court of Appeals came out with its opinion. And I also want to thank the subcommittee for tackling this. This is one of those issues where it is threading the needle. And that's what we do here. Some bills are more difficult than others at threading the needle, and this is one of them. There's no doubt about it. This is one of them. And we try to avoid the unintended consequences kicking in. Sometimes we're successful. Sometimes there are things that we address a bill like this years ago, and then X number of years in the future, circumstances change, technology changes that couldn't have been thought of, a generation ago or more. We're probably at the point right now, maybe or maybe not with this issue, that we'll be tackling issues that, and we will think that we will have covered it. But a generation or more from now, there'll be a development in whatever area, technology or otherwise, that we couldn't possibly have foreseen. And this committee will be back here without me, that's for sure, to go ahead and address that whenever that occurs. And that's the amazing thing about criminal law in the technology age, is that it is fluid, to say the least. So I appreciate the author and I appreciate the subcommittee tackling it. Very, very difficult. Ms. Kendrick, did you have something? I see your light flashing.
I wanted to thank the guest of Representative Blackman, even though we didn't hear from her. I know she was going to come and provide some testimony, and that's got to be really brave since some of this thing happened to her. So I just wanted to thank her for coming as well.
Thank you for saying that. I appreciate your saying that. Is Representative Blackman, does your guest did either one of them want to say anything? They're more than welcome to.
I just think she wanted to be available for questions.
Okay.
I mean, I certainly don't speak for them, but very interested in making sure that this, I think what we all believe to be inappropriate behavior is criminalized in the future. Thank you.
Thank you for your efforts. All right, I think we've given Representative Quick a long time to think about that potential amendment and any other amendments that may occur, but what's the pleasure of the committee? Vice Chair moves due pass of House Bill 9 by substitute LC 297392S, as in Sam. Are there any amendments? Ms. Quick.
Mr. Chairman, I would move that we amend LC 297392S at line 28 by deleting the words "in" and "the," and line 29 by deleting all of the words before the semicolon, such that it now reads, so paragraph 1, the lawful activities of law enforcement and prosecution agencies, semicolon, or.
Ms. Quick proposes an amendment on line 28 to add a semicolon after the word agencies, strike the words in the investigation and prosecution of criminal offenses, but preserving the "or" at the end of line 29. Is that correct?
Yes, sir.
Okay. There's a second by Mr. Setzler. Any discussion on the amendment? Any discussion on the amendment by Ms. Quick? Seeing none, all in favor of the amendment signify by saying aye. Aye. Opposed? The ayes have, and the amendment is adopted. Are there any further amendments? Ms. Quick. I'm sorry, Ms. Price.
I'm still a little bit hung up on line 24 because of the word privacy. Because there may be situations where a person doesn't expect privacy, but they expect not to have a permanent record of their activity. And there is a distinction, and I'm not sure how to make that. And not being a legal beagle, I don't know, what privacy means, and if that's the word we really want there.
Mr. Spast, if you look like you've got a comment.
I do. That reasonable expectation of privacy is a very common phrase in criminal law. We've got a well-established body of law about what's reasonable, what's the expectation. So I submit that is probably the cleanest way to describe it, to put everybody on notice, and that's when this statute gets analyzed later, that's going to be something the courts are going to recognize as a phrase. So I don't know how else to do it. I would be reluctant to try to create a new phrase. Because reasonable expectation of privacy has been pretty well litigated.
But because we're in these devices and permanent recording of activities,
So you're trying to draw the distinction between the expectation distinction of, well, I don't care if everybody sees versus.
A recording of
if I
such.
record-
Mhm.
I don't, I would have a very hard time trying to draw that distinction. I mean, you're either expected to be private, or this modern age, I think you know that it can get filmed. So I'll have a hard time trying to come up with an additional balance related to whether or not I want it recorded.
You've got the consensual aspect of this and the surveillance.
Well, if everybody's
Porter-
happy with that, I am too.
Mr. Porter, did you want to?
The only thing I would note is that in Representative Price's scenario is that you also have both in the unlawful eavesdropping and surveillance statute, which is the next statute, you have, and in this statute, you have a consensual element. So you might have someone in a situation, a public situation that is being filmed, but if they don't consent, there would still be crime being committed. So there's a consensual aspect of both of them.
Okay, thank you.
Thank you. Mr. Sessler? Nope. Mr. Trammell?
Mr. Chairman, I would offer an amendment at line 30, after the word device, to insert used in the ordinary course of its business, such that the line would then read, a business's or entity's surveillance device used in the ordinary course of its business, comma.
Does the author have a opinion he'd like to share on that proposed amendment?
This is fine with me, Mr. Chairman.
Discussion on the amendment. Is there? Mr. Trammell, can you go ahead and repeat that for council?
So at line 30, after the word device, insert the phrase used in the ordinary course of its business.
Council, do you? Do any issues jump out at you? Okay. Any further discussion on the amendment? The amendment is on line 30, a business or entity surveillance device used in the ordinary course of its business, comma. All in favor of the gentleman's amendment signify by saying aye.
Aye.
Opposed? The ayes have, and the amendment is adopted. Are there any further amendments? Ms. Kendrick? Okay. Seeing none. On the only question I have there, and I appreciate the council circling back on that, do the words, what I'm used to seeing is including but not limited to is the term of art that I've just grown used to for no rational reason probably, but do the words without limiting the generality of the foregoing. There's something about that that just, I mean, I'm not, and it's not a nitpicking, I'm just wondering, does that language provide the absolute guidance to the court that we want it to? Sure. Take your time. Mr. Trammell.
Mr. Chairman, with respect to the language that we find in the bill, this is the same language that we find in 161160 in the defined term device. So that without limiting the generality of the foregoing is existing in the preceding statute. It's not to say we couldn't do something different, but.
Well, that consistency makes me feel better anyway. I mean, It's not a mountain to die on. I just want to make sure that we're not. So it would potentially read photographing, videotaping, recording, or transmitting visual images, including but not limited to a camera, photographic equipment, video equipment, mobile phone, or other similar equipment. What's the pulse of the committee on that amendment? Mr. Bodie?
I completely agree with the chair. I just have not seen that language, the general language at all in any, not too many criminal statutes that we use on a daily basis. I think anytime a judge, a prosecutor, a criminal defense attorney will look at the including or the including but not limited to is something that we see on a daily basis. So generality, that's just not a term of art that we use every day in the courtroom. So I would definitely want that eliminated.
Mrs. Cooper?
Thank you, Mr. Chairman. I'll be glad to make that amendment.
All right, Mrs. Cooper proposes the amendment. Device means an instrument or, on line 13, device means an instrument or apparatus used for observing, photographing, videotaping, recording, or transmitting visual images, including but not limited to a camera, photographic equipment, video equipment, mobile phone, or other similar equipment. Does that read? I appreciate that. Right, so that you get some separation before including, included but not limited to, so that there's separation between those descriptive phrases. Okay, thank you. Mr. Setzler.
Thank you, Mr. Chairman. There was a change that's been made in the substitute that was not in the subcommittee, which is the term observing. It was photographing, videotaping, recording. Observing was added in this sub. Can I ask a question to the prosecution? If someone were to use a mirror, for example, I think it's clearly an instrument or apparatus. Is the kind of enumeration of electronic devices, does that have the tendency to exclude a mirror and create an inference against it, or is it, you think we're fine?
Actually, in every version that we've had a hearing on this, we noticed that we didn't include observe as a means of either committing the crime or as a device that doesn't record but merely observes, and so we asked for that change in both of the Senate hearings and in the subcommittee.
Yeah. And Mr. Chairman,
You could have a non-recording observation mirror on a stick.
Yeah.
All you're doing with this language is basically telling the world the type of devices that you're generally after, but you haven't excluded any other device.
As long as the listing of only electronic devices doesn't exclude something manual like a mirror, I think we're fine.
Which
Okay.
does not. And that's not excluded, correct?
That's correct.
Okay. On the amendment proposed by Representative Cooper, all in favor say aye.
Aye.
Opposed? The ayes have it, and the amendment is adopted. Are there any other amendments? Seeing none, on the motion of now do pass by substitute of HB 9 LC 297392S, all in favor signify by saying aye.
Aye.
Opposed? The ayes have it. The motion is adopted. Thank you, Representative Blackman. Thank you to the subcommittee and full committee. Representative Cooper has an announcement. Press your button.
Thank you, Mr. Chairman. I'd forgotten how much I enjoy these meetings. I've been really busy. I'll try to make more of them. I would like to invite the committee members to Health and Human Services tomorrow at 2 o'clock. The first thing we are going to do is have a presentation by WellStar. This committee takes up our problems with drugs and addiction, and Wellstar has come up with a program for their physicians on the correct way to prescribe. They have shared it with hospitals across this state, and I thought you might find it interesting as we fight this opiate addiction war. So anybody that would like to come, we'll take them first. And I'm very proud of Wellstar for being willing to have made this and then put it out, and they've done webcams and through the Hospital Association to make it available to hospitals all over the state. So
Thank you for that.
anybody's welcome.
Thank you for that invitation. Do appreciate it. Let me give you a heads up. On Wednesday, the committee is likely to hear House Bill 65 by Representative Peake. That is the legislation that is, I think, currently in the medical cannabis study group. That study group is making a recommendation which is distilled into a substitute, I think, for us, for the full committee to consider. And that legislation seeks to expand the conditions by which an individual can potentially access the card, a medical cannabis oil card for treatment. That meeting will occur on, as of right now, we'll plan on having that hearing Wednesday afternoon. It'll start either at 1 or 1:30. The notice will be clear on that, and I apologize that it was a little bit unclear on this notice. That's my fault for this meeting. What we will do, it'll be a hearing only, just to be clear, that's be a hearing only, time to be divided equally between the pro and the con side. There will not be a motion accepted during that meeting. Is simply a hearing, a public hearing on the recommendations of the study, of the medical cannabis study group. We'll also seek in the next 48 hours to make sure that we have comfortable consensus on the drug trafficking bill and the fentanyl bill that we discussed today, in the hopes of going to a motion on that first and then getting into the hearing on 65 on Wednesday. That's the plan as of this minute. So any questions, members of the committee? It'll be it'll likely be one, because I want to make sure that we cover the fentanyl trafficking bill first and then provide ample equal time to both sides of this, of House Bill 65. So it's likely to be 1 o'clock unless there's some floor scheduling matter that occurs that will cause us to push to 1:30, but likely 1 to 3:30 as of now. Okay. Thank you, members of the committee. We're adjourned.
Ed?